Hello there. Uh, well, I regret that I can't be with you in person at this year's MDAW. I'm glad that we have the opportunity to use the wonders of technology to try to further your debate education. About me, my name is David Coates. I am the Assistant Policy and Lincoln Douglas Coach at Egan High School. And this is not my first foray in criminal justice topics, which is why I've been asked to give this topic overview lecture. I debated the juvenile crime topic in 1996. I judged fairly extensively on the following privacy and civil liberties topics, making this the fourth time I have encountered criminal justice issues within the framework of academic debate. I was also selected to give this lecture in part because while in real life, when we're not suffering through pandemic lockdowns, I work as a data analyst for a consulting firm specializing in education law and policy. I do have an extensive legal education. I studied legal history at the University of Chicago under Dennis Hutchinson, current editor of the Supreme Court Review. And I have a law degree from the University of Minnesota, where in addition to the core criminal law curriculum, I also took specialized advanced classes in state and federal constitutional law, forensic science, habeas corpus, and the death penalty, and was a line editor of the death penalty symposium issue of the Journal of Law and Inequality. So, asked to talk about the topic because I know a thing or two from studying issues deeply related to the topic. Before we go any further, if you have any questions that are topic related, I can always be reached by email at coat0018@umn.edu. I will try to get back to you as quickly as possible should you have substantive questions related to criminal justice. This lecture will proceed in two parts. The first will be a general overview, the substance of federal involvement in criminal justice, and the second part will be a brief discussion of practical applications, the history and legal debates surrounding federal involvement in the criminal justice system may have on you as you prepare to compete this fall. First subpoint, federal involvement in the criminal justice system. I think that the most important thing to write down about this is the oft-repeated quote that there is no such thing as a general federal police power. There is no such thing as a general federal police power. You may ask, what is meant by this? The federal government operates many policing agencies. A common criticism of federal policing in the academic literature is that every federal agency, whether or not it serves a primary law enforcement purpose, has its own armed police force. What's really meant by this statement is that while states are free to criminalize whatever behavior they like, as long as the process by which they do so does not violate guarantees found in state and federal constitutions, the federal government has power over criminal law only to the extent that that power is delegated to it by the federal Constitution. The federal government has power over criminal law only to the extent that it is delegated that power by the federal Constitution. There are only a very few specific crimes that the Constitution mentions the federal government having power over. These are treason, piracy, counterfeiting, offenses on the high seas, offenses against the law of nations, and crimes committed while in actual service in the military. That is a very, very short list. That is a very, very short list. So the next question that might come to mind is, if the express power of the federal government to criminalize behavior is so small, why is there such a proliferation of federal crimes on the books? Why do we frequently, if we read newspapers or watch television news, hear about high-profile federal criminal trials? And there are a couple of reasons for this. While the federal government's express power to criminalize behavior is limited, the necessary and proper clause of the Constitution implies that the federal government is able to criminalize behavior if doing so is necessary to carrying out its other enumerated powers. The federal government is able to criminalize behavior if doing so is necessary to carry out its other enumerated powers. Case in point, the federal government has the power to establish post offices. It necessarily follows, according to this reading of the Constitution, that the federal government would have the power to criminalize behavior which takes place in post offices, without which power the Postal Service would not be able to operate. Similarly, the power to make legislation governing federal lands, specifically mentioned in the Constitution as forts, arsenals, dockyards, and other needful buildings, necessarily implies that the federal government has the power to criminalize behavior on those lands it owns. But you may say that crimes occurring in federal buildings and on federal lands are a very small part of the sum total of criminal enterprise going on in this country. Where does the federal government get the power to criminalize so much behavior? The answer to that lies in interpretation of the Interstate Commerce Clause of Article 1, Section 8 of the Constitution. The Interstate Commerce Clause of Article 1, Section 8 of the Constitution, which provides that Congress may regulate commerce among the several states. Historically, the interpretation has been that therefore the federal government may criminalize any behavior which has a substantial effect on interstate commerce, such that we have a frequently invoked piece of federal legislation called the Hobbs Act, which notionally is designed to punish robbery and extortion, which take place in interstate commerce, but in reality have been held to be completely constitutionally valid when used to punish people for committing run-of-the-mill armed robbery if it happens to affect a business which regularly operates in interstate commerce. The classic example is robbing a gas station located next to an interstate highway. Ordinarily, this would not be considered a matter of federal concern or something to make a federal case out of, but for the fact that we have the Hobbs Act, which criminalizes robbery and extortion interfering with interstate commerce. Expansive interpretations of the federal government's ability to use the Commerce Clause to criminalize activity persisted until the year 1995. In 1995, in the landmark case of United States v. Lopez, you'll want to write that down because this will come up frequently in debates. The Supreme Court, for the first time, held that a Commerce Clause justification for a federal criminal statute was too extreme to be justified under the Constitution. The fact pattern in Lopez is simple. Lopez was convicted for violating a statute called the Gun-Free School Zones Act, which did what it sounds like, made a federal crime out of unauthorized possession of a firearm near schools. But the Commerce Clause justification offered by the federal government for this law was, in the view of the court, extremely tenuous. The argument proffered by the government was that people carrying guns near schools deter students from showing up to classes. Those students who don't show up to classes will lack the proper education to be productive in the workforce, and the concomitant decline in economic productivity would eventually negatively affect the goods and services exchanged in interstate commerce. This justification was too much of a stretch for the court to handle. Justice Thomas, in writing his concurrence, wrote that an interpretation of the Commerce Clause to allow for criminalization of non-economic activity would render the Commerce Clause itself completely null by allowing the federal government to criminalize anything it wanted to, because anything you do tangentially affects interstate commerce. The holding in Lopez was bolstered in 2001 by the Supreme Court's ruling in a case called United States v. Morrison, another one you want to write down, United States v. Morrison, which held that certain provisions of the Violence Against Women Act were unconstitutional because they exceeded the federal government's Commerce Clause authority. Again, the government offered up a very tenuous Commerce Clause justification for the statute at issue, arguing that violence against women caused women to be absent from work, which decreased overall economic output and thereby negatively affected interstate commerce. Again, the court found that that type of rationale for federal regulation, criminal matter, of a fundamentally non-economic activity was a bridge too far. There are a couple of ancillary justifications for federal police power, which may or may not come up during the course of the season, but which you ought to take note of. One, the power of the federal government to make laws regarding naturalizing foreigners implies a constitutional justification for the federal government policing immigration. The power of the federal government to raise and collect taxes implies that there's a legitimate policing role in the context of tax evasion. Probably the most important of these in the context of the debate revolves around the 14th Amendment and the power granted to Congress therein to make appropriate legislation to enforce the equal protection and due process guarantees against the states, which Congress did by passing the Civil Rights Act of 1871. The Civil Rights Act of 1871 contains two important provisions which interact directly with the criminal justice system, particularly in the area of policing. Section 242 of the Civil Rights Act of 1871 provides for criminal penalties for public officials who knowingly violate rights, privileges, and immunities guaranteed by the constitutional laws of the United States or any state. Section 1983 of the Civil Rights Act of 1871 provides for civil liability for people who do the same thing. They can be hauled into court by their victims and sued for damages or equitable relief. Most interesting aspect of this particular piece of legislation, in Section 1983 in particular, is something I'm sure that you will discuss in great depth in camp, but needs to be stated here because it informs much of the jurisprudence surrounding the topic, and that is the doctrine of qualified immunity. Qualified immunity is not something that was envisioned by the Reconstruction Congress in 1871 when it passed the Civil Rights Act. There's no contemporaneous record of it having even been discussed in the floor debates in the House of Representatives. Rather, it is a judicially created doctrine which developed decades later. Qualified immunity states that a public official, for example, in this topic, a police officer, a forensic scientist, member of a sentencing commission, a prison employee, etc., cannot be held liable for damages for violations of somebody's rights, privileges, or immunities unless there was clearly established law that a person in the position of the defendant should have known about at the time the conduct took place, explicitly outlining that that conduct was illegal. The way that the court, over repeated denunciations from both sides of the political and jurisprudential spectrum, has held and applied the qualified immunity doctrine is to say that unless there is case law from your particular jurisdiction with a nearly identical set of facts holding a constitutional violation to have occurred, you are immune from civil liability under Section 1983. This creates a virtually impassable bar for plaintiffs who wish to use the statute to vindicate their rights, because it is rarely the case that there is an absolutely identical case from your particular jurisdiction saying that whatever a police official or a prison guard did to you was illegal is just something that is virtually impossible to find. Hence, the majority of cases brought under Section 1983 against people involved in the criminal justice field are dismissed on qualified immunity grounds because of the inability of a plaintiff to find an identical precedent. Obviously, given the sharp tone of the debates over this doctrine which have been occurring in the judiciary, and the fact that there is excellent literature on both sides of this question, talking about the need to balance the ability of the public to be protected from their public servants and the need for public servants to be able to be confident in their snap judgments made in the field. I expect this to be an issue which is debated frequently over the course of the season, and I should imagine that this is an affirmative that will not only be turned out by just about every debate camp in the country, but also something that will probably be included in the novice packet. Qualified immunity doctrines, I think, also will interact in interesting ways with more substantive types of affirmatives people seek to run. So an argument that might be made on the negative is that absent qualified immunity reform, whatever substantive reform an affirmative plan attempts to implement simply cannot be enforced, would have no deterrent effect on police behavior, nothing would change after the plan, barring abolition of qualified immunity doctrines in some form. One more important aspect, the interface between state and federal criminal law that needs to be mentioned, at least in passing, is the concept of dual sovereignty. As you probably know, the Fifth Amendment to the Constitution prohibits trying a person twice for the same criminal offense. But the courts have consistently held that this does not preclude the state and federal governments from separately trying a person for the same offense, as long as some element of that offense materially differs between the state and federal jurisdictions. An example, my old criminal law professor, who in real life is a federal public defender, liked to use is bank robbery. It is illegal to commit robbery in every state. Every state criminal code has a robbery statute in it, but it also separately is illegal under federal law to rob a federally insured bank, provided that a federal prosecutor can prove beyond a reasonable doubt that the bank a defendant robbed was federally insured. There is nothing preventing federal and state governments from each getting a bite of the apple in these situations. This is not something that really happens all that often, but it is something to note because there is a solid body of literature criticizing the dual sovereignty doctrine as being extra textual and something that was not envisioned by Congress at the time the Bill of Rights was written. That's the last broad concept I would like to introduce for the purposes of the first half of this lecture. You may now be thinking that the federal government is relatively toothless in its ability to regulate criminal justice behavior carried out by state and local agencies. After all, immunity doctrines generally bar federal prosecutions or successful civil lawsuits in federal courts. However, the most successful mechanism used by the federal government in this area is relatively indirect, derives from Congress's spending power. I wonder how many of you are familiar with Byrne Community Justice Grants, as BYRNE, or the 1033 program, both of which are designed to funnel monies and surplus federal equipment to state and local policing agencies. However, Congress has the power to enforce conditions on funds or material given to state and local agencies as long as those conditions are not unconstitutional in and of themselves. So there are conditions which exist in the status quo on Byrne and 1033 distributions to state and local police agencies, but a common argument in the literature is that these don't go far enough in reining in the behavior of bad actors within the criminal justice system, or that the types of equipment that are doled out under these systems need to be changed. You'll see frequently arguments in the literature about police militarization. Many authors specifically dislike the fact that surplus military equipment is being given to police departments. They argue that handing out this type of equipment causes police officers to view themselves as soldiers in a war against an enemy, as opposed to being public servants who are a part of the communities that they are supposed to serve. So, potentially fruitful area for affirmative research would be whether these programs ought to be curtailed in their entirety, or whether additional conditions to rein in bad behavior in terms of policing mostly, but also sentencing and forensic science abuses within the states ought to be attached to funds dispersed under these programs. So I hope that that is a helpful general overview of the interface between federal and state governments in the particular area of criminal law. It may leave you asking yourself what you're supposed to do with all of this from the point of view of strategic and persuasive debating in the season ahead. After all, how are you supposed to navigate a topic which calls for federal intervention in an area where, according to the Bureau of Justice Statistics, 93% of meaningful decisions, to wit those related to criminal sentencing, are carried out at the state level? And I think that from the point of view of pure debate tactics and substantive development, there are a few things that you should consider as you plot out what types of arguments you would like to write and practice running at camp and would like to make in the season ahead. I think first, there is always the possibility under this topic of writing an affirmative which is restricted to reforming federal law enforcement agencies, which doesn't attempt directly to alter the behavior of the states. As I said in the introduction to this lecture, there are a multitude of federal law enforcement agencies. Every federal agency, including the Postal Service and the Department of Agriculture, has its own policing force. A policy which alters the way that a federal agency operates, or which abolishes the police powers of a federal agency in their entirety, might be strategically beneficial to run on the affirmative. Granted, the types of advantages that you can claim with these are small compared to broad, sweeping reforms that attempt to suck up the entire country. But on the flip side, the types of advantages you can claim are specific and detailed, and it's very difficult for the negative to craft a counterplan that is able to solve for them without linking to whatever disadvantage they're running against you. So if you're thinking in terms of a small aff, which avoids a lot of problems related to federal intervention, stripping police powers from particular federal agencies like the IRS, Immigration and Customs Enforcement, etc., or abolishing a federal agency like the FBI in its entirety is something that you may want to do. Similarly, as I mentioned in the constitutional law overview, the federal government has the power to make regulations concerning the military. The military has its own criminal justice system, which operates in parallel to the civilian criminal justice system, using its own set of criminal statutes found in the Uniform Code of Military Justice. This is solely a federal issue, and the advantage of claiming to solve for criminal law in the military is that you can potentially claim large impacts based on relations with foreign countries, but you do so while arguing for the implementation of a policy which is by itself a fairly small one that affects a fairly small percentage of the population. That is a way to avoid these types of states and federalism debates that I fear will be extremely common on this year's topic. On the flip side, I think that it's possible to embrace the idea of broad sweeping reforms on the affirmative if you are capable of developing clever solvency deficit and disadvantage arguments against the inevitable state's counterplan. As I mentioned earlier in the discussion of dual sovereignty, there is always the possibility of the federal government finding some way to prosecute you for something that a state has already prosecuted you for, or for something which isn't even a crime under state law. For example, marijuana is legal under state law in California, but it's only through the forbearance of federal prosecutors there that people who buy marijuana in a state licensed shop and smoke it under circumstances the state says are legal are not prosecuted under the Federal Controlled Substance Act. Such that I think that a solvency deficit argument you can be making on the affirmative if you are choosing to run an AF, which is a broad, sweeping, and nationwide reform, is that state-level reforms do not repeal federal law. They may alter the ability of state officials to cooperate or collaborate with their federal law enforcement counterparts, but they do not prevent, and by their very definition can't prevent, federal law enforcement officials from enforcing federal law on their own. Such that an argument you could be making against states is that states acting on their own without federal follow-on always leads to the possibility of federal law enforcement officials simply filling in, arresting people, subjecting them to shoddy forensic science, and sentencing them. for conduct which may be legal in the state, but may be illegal under federal law, such that only implementation of a nationwide federal policy is able to solve for these problems. Of course, winning an argument like that is contingent upon your being able to categorize the impacts which you claim in the 1AC as being in some way more important than the political process disadvantage which will inevitably be coming. That, well, I wish we were doing this face-to-face so that there would be time for in-person questions, is about all I have in terms of a broad overview of the interface between the state and federal governments in the area of criminal justice. The key takeaways from the point of view of debate strategy and tactics ought to be these. Running an affirmative which is specific to federal reforms only allows you to evade some of the most common substantive topic disadvantages like federalism, but severely circumscribes your ability to claim large advantages without relying on an excessive and improbable number of internal links. Whereas on the flip side, broad, sweeping, nationwide reforms invoking Congress's spending power or Congress's ability to enforce the 14th Amendment against the states will certainly link to a lot more disadvantages, both of the structural nature, like federalism, but also of the perceptual nature, like politics, but on the flip side, allow you to claim large structural advantages in the 1AC, have interesting built-in defenses against counterplans, and arguably, in my view, are easier to categorize as being particularly important or significant to many members of your audience who probably are not overly concerned with the minutia of what federal law enforcement agencies do what, or what types of sentences federal courts are able to hand down, but rather do envision the criminal justice system as if it's something, I think that I've clearly established it definitely is not a unified, nationwide, holistic system of crimes and punishments. So I think in terms of case selection, the choice is entirely up to you. I think that if you are more comfortable engaging in a lot of topicality and critique debates, you should be looking at small affirmatives which deal only with individual federal agencies, federal statutes related to forensic science, altering the federal sentencing guidelines which are in place in the federal courts, doing something like banning the death penalty in the military or in the federal system, where granted it's hardly even used. Whereas if you are most comfortable having a large policy-oriented debate, you're comfortable garnering offense against disadvantages, running 2AC disads to counterplans, making and blowing up in the 1AR substantive arguments about the inability of the most common agent counterplan to solve for problems on a federal level, you should be looking at a large stick affirmative which seeks to impose some sort of nationwide standard which would also be binding on states and localities. In these instances, abolishing qualified immunity, passing nationwide legislation to ban the death penalty, passing nationwide legislation to ban life without parole, implementing uniform nationwide standards for forensic science, implementing nationwide rules altering the admissibility of different types of forensic science in criminal cases might be the best course of action for you. The question is simply, in the context of an area of debate where so much authority has always been possessed by states rather than the national government, you want to run from that fact by running a federal-only AF, or you want to embrace that fact by running an AF which calls for the federal government to enforce nationwide policies against states and localities. The choice is entirely up to you. I hope that this has been a helpful overview of the way that the criminal justice system is constituted in this country, which is relatively unique. And once again, should you have any specific questions, or should you desire specific suggestions about reading material which is specific to these issues, please feel free to email me at coat0018@umn.edu. Thank you very much.